the nomination papers. Now, Lordship may permit me to read now paragraph 9.
Madam. Representation of People's Act.
Please, paragraph 9. Thus, from reading of section 195 CRPC, it is abundantly clear that no court shall take cognizance of any offense punishable under section 172 to 188 of the Penal Code 1860, except on the complaint in writing to that court or by such officer of the court, as the court may authorize in writing in this behalf by or some other court to which the court is subordinate. Needless to state that the provisions of section 195 code are mandatory and non-compliance of it would vitiate the prosecution and all other consequential orders. In the case on hand, the complaint is not filed by the court or officer of the court or by a public servant, that is the returning officer. Therefore, as rightly submitted by the learned counsel for the petitioner, that the complainant has no locus standi to file the complaint against the petitioner for the offences punishable under 172, 181, 182, 198 IPC. Admittedly, we are not coming within that ambit. Now, kindly see para 10. This is what, is what we have now filed. By reading contents of para 3 and 4 of the said letter, it is evident that if an offence is committed under section 125A of the Representation of People Act 1951, it would be open to any aggrieved person to move petition before the appropriate court of competent jurisdiction for action in case of any false declaration or concealing of information in the affidavit in form number 26. In that case, it will no longer necessary to proceed under CRPC for returning officer to move the competent court in a relation to so and so. Therefore, if only 125A is alleged, it would be open for the aggrieved person to move the court.
125 was not the offense at all in that
It is
case.
one-
Where was it necessary for deliberation on that? 125A was not the offense in the case.
In this case,
Come to what was-
171G madidru.
171G houdu.
ಮಾಡಿದ್ರು.
125A ಬಗ್ಗೆ
Yeah,
ಬರೆಯೋದು.
but therefore that position, the learned single
All
judge,
right, but there was nothing to interpret
what the learned single,
125A.
the learned single judge makes that position clear. That 125A idre baro. I'm only just reading.
So
This
not
is the
the
judgment.
ratio, not the ratio at
No,
all.
but this is the judgment they relied upon for the learned single judge at the time when the interim order was granted. This was the judgment which was relied upon, and this judgment itself clarifies that if it is a prosecution 125A alone, standalone, then question of bar under 195 will not apply. But insofar as merits are concerned, but he had filed a declaration before the returning officer that he is a resident of number 350 Chitta village, but which is lying in Bidar South
He is
constituency.
not a resident of that village.
No, he is not resident. That is my case. And in order to substantiate that, what we did was at the time, and these are all will come. These are all part of the memorandum of complaint itself. We filed application before the Panchayat authorities. They gave an endorsement to that effect that there is no sanction plan, though no electricity bills, no water bills in respect of that premises. Not only that, but I have also produced photographs which were produced before the learned magistrate as well. But Lordship may kindly peruse those photographs itself of the
Photographs?
scheduled property.
Of the property.
How that is a vacant site. Sorry,
So he is a resident of that vacant site is what he had known.
that is their case. He is not residing there.
Hmm.
Allah sir, let me complete. The
Okay.
reason why also he files this is he is a resident of Bidar city, and Bidar city there is a separate assembly constituency. Bidar South is where he wanted to contest, which he contested eventually, and he shows that as the address. And this is a false statement made in the affidavit. And these photographs, endorsement issued by the Panchayat authorities. Now, of course, the Aadhaar card also shows that he is residing at Bidar city itself.
Hmm.
Aadhaar card copy.
No, at the relevant point. Then he was residing there or
Allah, idu Aadhaar card issued
ಅಲ್ಲ ಅವತ್ Aadhaar card
Aವಾಗ-
issued
ಅವಾಗ-
when?
much earlier. So this is issued on 31st January 2017. Madam,
ಇದು ಯಾವಾಗಿನ ಎಲೆಕ್ಷನ್ ಇದು?
ಇದು ಮೊನ್ನೆ 2023.
23.
No, he is at, I don't think A member of the Legislative Assembly, once we filed a complaint, they have put up a shed. And I don't expect members of the Legislative Assembly no, not for any other purpose, being a representative of a people of such a large constituency to stay in a shed or in 350 Chitta village. Therefore, the complaint learned magistrate takes cognizance and has considered, recorded the sworn statement, not only of the complainant, but two other witnesses,
So according to you, he is not the resident of Chittawadi,
350 Chitta village,
Chitta village.
Chitta village.
Chitta village, but he is resident of Bidar
Bidar city.
city,
This is coming in Bidar South.
South constituency.
South Constituency. And with an intention, but not only, this is not just a mere slip, with an intention to get elected from that constituency, that is the allegation. He has shown that as the address.
Ashana?
Nam prakar, this is the prima facie material we have produced. Number
Anyways.
of documents we have produced.
State is not there.
State.
Anything in replies?
Number one, my lords. There are two sites are there, 349 and 350.
Hmm.
Adjacent site belongs to my brother.
What is the advantage that he would get?
Well, that's what.
Advantage is.
No, that's what.
One ನಿಮಿಷ,
If
sir.
I am to, that is it.
What is the advantage that he would get by shifting?
If I am
residence?
contesting, yes, if I am
No,
contesting.
is it that was a reserved constituency? or
No,
an
he
independent
wanted to
constituency?
he wanted to show that he is contesting from, so he is residing in that area where he is contesting. But this would have been, in
No, that is for the purpose of nomination.
not only nomination, in electoral matters, more political matters, these questions have a definite relevance. If I am, for instance, residing in Bangalore, and if I want to contest from Bijapur, I would try to show that I am residing there. This is one of the election issues. Would be look at this. He doesn't stay here. He stays elsewhere. He is contesting from these elections. In order to overcome that possibility, he intentionally filed this false affidavit. That is our case.
Yes.
Of course, these are all matters which require
Trial.
Trial is smart. I don't want to say anything
If
more.
I am the resident of Karnataka, I can contest the Karnataka Legislative Assembly elections throughout Karnataka. Therefore, there cannot be any dispute, advantage or the disadvantage so far as the contesting the elections from Bidar South or Bidar North.
Not legally, it is not advantageous. No, politically, it is advantageous. That's all we are saying.
Manas, let his statement be taken into good. That itself is my answer. That itself is my answer.
So legally it is not advantage.
Legally, there is no
So-
bar.
so-
That's what I say.
So.
Sir, legally there is no bar. Legally it is not advantageous. According to politically it
No,
is
no,
advantage. We are
what the
not
learned
here
senior counsel.
seeing the advantage of politics.
No, no, learned senior no.
So I'll
Learned
take-
senior counsel.
I'll take
no,
his,
one
I'll take his argument as my argument.
The clarification. What learned senior counsel is saying is there is no bar. Admittedly, there is no bar.
Bar, correct.
But sometimes these things are matters in politically. All that I'm saying.
Further, I've got a lot more documents to show. I'm staying there, electricity connections are given. Gram Panchayat had given a permission, certificates are there. I have produced it, all those certificates, my lord. I thought it may not be at this juncture so much of, but they're already part of the records, my lord. Court can straight away take, I need not, shall I show it, my lord? No.
Yes.
So then, my lords, the legal question which I'm posing is, if the voter list, my name has been entered, it is a prima facie proof that I am residing in that area, in that house. From the year 2014 onwards, up to 2024, the voter list depicts that I am residing in that village. Therefore, my lords, if at all they have got any grievance regarding my entry into that voter list, under section 24 and under rule 23, they have to file an appeal before the competent authority, that is the CEO for that matter. In the absence of that, it cannot be taken as it is a false affidavit. Number one, my lords. Number two, if court permits, my lords, there are two circulars are there from the Election Commission of India, how it should be treated as such. Is it, my lords?
Sorry.
First, my lords, I want to go to the judgment of one of the judgment, my lords,
Which judgment, sir?
no, my friend, have you given it? Al Sahib ಕೊಟ್ರೆ ಇಲ್ಲಿ ಸಾಹೇಬ್ರು ಕೊಟ್ರ
ಯಾವ್ದೋ ಒಂದು ರಾಬರ್ಟ್ ಕೊಟ್ಟಿದ್ದೀರಾ?
ಮನಸ್ ರಾಮ್ ಜೇತ್ಮಲನ್ 19 ILR 1990
ಹಾ,
ಕರ್ನಾಟಕ 1907.
ಅದೊಂದು ಕೊಟ್ಟಿದ್ದೀರಾ? ಇನ್ಯಾವ್ದು?
One first I'll go to that. Para number 35 and 36. Here, my lords, the only in 2 sentences I'll complete the facts as such.
Hmm.
Ramjet Malani has shown that his address of residence is the guest house in Indian Express, guest house situated at behind the MG Road for that matter.
Hmm.
And he was ultimately elected as a MP, and that question was raised before the Honorable Court. And the Honorable Court has said that if such a thing is there, in our opinion, the submission of the learned counsel overlooks the correct position in law. It is a well-settled principle that if a court has got the jurisdiction to decide a case, but not an issue involved in the said case, the course open to the party concerned is to have the said case pending and to have the issue settled by the court, which has the competence to decide that issue and produce the said order before the so and so. My lords,
Yes.
so exclusive jurisdiction has been given. In the next paragraph, my lords, it has been given. Exclusive jurisdiction has been given. Page number 1953.
1953?
Page number,
ಇದರಲ್ಲಿ.
in the next page, my lord,
ಹಾ.
has given to the appellate authority in this regard regarding whether he is a resident of that particular so and so or not. So in the absence of that, para number 36, I can skip over and come to that point. In the present case, what has been happened is that an election petition had been filed against the election of the first respondent, and the only ground raised this election petition was that the inclusion of the name of so and so is. Then what the court has suggested is, you please obtain the certificate and produce